Okay, we'll go in. Okay. All right.
Good evening, Crime Talk aficionados. This is Crime Talk. My name is Scott Reisch, and it is Tuesday evening, which means that is our live program. So want to thank everyone for being here early. It looks like we had Patricia Beverly, Tabitha, Tony, Christina, Miko, Eliska, Sky Steel, Jojo Beans, Lucia D. Thanks for joining in. Thank you for being here right on time. We appreciate it. For those of you who have never tuned in before, my name is Scott Reisch. I am a practicing criminal defense attorney here in the state of Colorado, which most of my practice is limited to criminal defense, both state and federal court. And we've pretty much tried just about every kind of case you could possibly imagine, both here or in another jurisdiction. So we like to think we have a little bit of knowledge from which to speak as to how a case is presented, both on the prosecution side and the defense side, what they're thinking, why they're doing it, and trying to explain what's really going on. We started this channel about 2 years ago, simply for the reason because it was so frustrating watching the evening news and broadcasters trying to explain a case, and certainly they can't do it in the 30 seconds that they have, let alone try to explain it when most of them didn't know the difference of any of the court proceedings, what was going on, and frankly, why something was even taking place. That's why we've done it. It's been a lot of experiment over the years, trying to do things. We're always trying to improve. For example, we're going live this evening. We're both Facebook and YouTube. And then tomorrow, it's been one of those days. Tonight, when we get done here, we will also be going to our Patreon group. Now, for those of you who aren't familiar with Patreon, you don't have to join. We give it all away for free. But sometimes we've had as many, I think, as 4,000, 6,000 people on our events. And man, the questions are flying by and you can't really even keep up. And with the Patreon group, it's a much smaller group. And literally, we can try to answer all of your questions as they come in. With a little added perk is that we have a phone line and we give that out to our Patreon members, and you can call and you can talk directly with me about what's on your mind and talk about a case. Frankly, if it's if you disagree with me, we'll give you priority. I think we can have 10 callers in the queue. Don't think we've had 10 yet at any given time, but we're working on it. It will come. So thank you for everyone. And also want to, if you haven't been here already, we would ask that you subscribe, hit that little like button. And as always, leave us a comment here. We'll try to answer your questions as they go by. Not telling anyone they have to do it, but when they do those super chats, they come in big and bold, and it's a lot easier to see when it comes to just seeing them pass by the screen when they really get rolling, that's for sure. And I can always go back to those as well. And so that's kind of who I am. What are we going to discuss tonight? Well, the first story we're going to talk about is Chad Daybell. Now, we put that up in our video that we put up this evening. It was a much shorter video than we've been doing recently, just because we knew we were going to go live and we'll be talking about this. And obviously, Chad Daybell, through his attorney, Mr. Pryor, filed a motion saying, my gosh, dismiss all these charges. There's no evidence to support these charges. Yeah, that's going nowhere. Then we'll talk about the Kyle Rittenhouse case. Now, Mr. Rittenhouse, he has an attorney. He's got kind of a group of attorneys that have volunteered some of their time, but his attorney was on TV the other night and explaining why everything was self-defense. Now, certainly the attorney wasn't there, so it must have come from Mr. Rittenhouse's story. So we can talk about that and let me know. These are the type of cases where it seems like people have drawn their lines as to who they believe, as to, was there Mr. Rittenhouse, is he a murderer? Why did he have a gun? He's underage. To he's absolutely innocent. It's self-defense. Those are tricky questions for sure. The police obviously moved rather quickly to file charges against the young Mr. Kyle Rittenhouse, but he, he's going to have a lot of things to work with, so to speak, when it comes to presenting a defense, for sure. The, one thing is clear about all of these riot videos is that nothing's absolutely clear. Is it the kind of, it changes, and literally it can change from you're the aggressor to the non-aggressor retreating person, and suddenly it's self-defense, or maybe it's not. The jury in that case, if the matter gets to trial, is certainly going to be have a lot on their minds. There's a lot of juries out there. They're going to have to make some real important decisions, and some of the decisions may not be what a lot of people or some people are not going to be happy with. And there's a possibility, if these juries don't come back with the popular results, so to speak, places could burn again. So those jurors are going to have a lot to think about. They're going to have to worry about their own safety, which is unfortunate. Jurors should, they're going to be doing their public service, and they're going to, be making the best decision that they can with the information that they have, following the law that the court gives them, and then, making the best decision possible. That's it. And, no one should be threatened because of, jury service. So we shall see. And then also we'd like to talk about the Jacob Blake matter. Now, a lot of people didn't like my discussion. I think it was late last week, where we talked about basically why the officers in the Jacob Blake matter would not be charged. And as you've noticed, the cases where officers have been, terminated from their positions, fired immediately, and prosecuted, those cases, they were all done rather quickly. And in this particular case, the officer has not been charged. And we talked about it in our video. This was last Friday, where we talked about why these police officers are such bad shots, and why it takes so many shots to do what they do. And really, because it's based on their training. But in that, the Jacob Blake case, it's much more complicated, because they actually found a weapon in the car, and it looked like he may have had it on his person at one point. But, the question is was that reasonable to be shot in the back 7 times? Yes, the taser didn't work, but really 7 times? Wow. I mean, I'm not saying my analysis, I'm not saying that's my belief that's right or wrong. I'm simply saying what I think is going to happen based upon the law in these particular cases. And, I got flack, the Ahmed Arbery case. People are like, oh man, those guys, the dad and son, that was self-defense. And I'm like, yeah, no, it's not. Look at the jury instructions. Not self-defense. They pursued somebody. He wasn't committing a felony. You can't run up to a car with a shotgun, point at somebody, and then say, oh man, he got it away from me. And he shot me. I mean, so I took flack from a lot of people who thought that the Ahmed Arbery case should have gone the other way. I'm like, no, that's just pure stupidity. Those gentlemen should not have pursued Mr. Arbery. They shouldn't have got out of the truck at all. And you can't go around making citizens arrests when you have no real proof that a crime has been committed, let alone a felony. So it was, so I get flack either way, no matter what I say, but I'm basing what I think is going to happen based upon the law and the facts that we know. And I will be the first to say that if the facts change, I will let you know. That's what we do in the practice of law. I give the best advice that I can with the information that I have, but it's always subject to change based upon new information and new facts. And, a lot of people think, oh, these defense attorneys, they lie. They're out there just making stuff up. No, you have to have a reasonable basis to do that. Why? Because juries are not stupid. Jurors consist of 12 very smart people, and they don't get duped that often. I assure you of that. Maybe every now and then they may make the wrong decision, but for the most part, they get it right. They take it very seriously. And that's what defense attorneys do. Even prosecutors have to do that. Okay, some new information is coming about. How does that affect my case? You can't just ignore it because you think somebody's guilty. You have to deal with it. And if you can't deal with it or counter something, then you're not being intellectually honest when it comes to evaluating the case. And I think in all of these cases, they've got a lot of legal issues that could go either way. It's not a slam dunk. There's no way to say Kyle Rittenhouse is going to have his charges dismissed. There's no way of saying that he's going to go to trial and be found not guilty of everything. There's no way of saying he's going to go to trial and be found guilty of everything as well. You just don't know how the evidence is going to come out, how it will ultimately be presented. And guess what? At the end of the day, the court of public opinion doesn't matter in the court of law. So that's what we're going to talk about this evening. So first we'll talk about Chad Daybell and the Lori Vallow matter. And Julie Hellman did a big super chat. Thank you very much. First of all, her question is Chad not also charged with the wrongful death of the children like Lori? No. And as you may recall, Julie, the prosecutor dismissed the abandonment charges early on. They're charged now with the felonies relating to the delay, destruction of evidence, failing to basically report that information. Lori Vallow has the misdemeanor charges remaining in the original case she had, which had the desertion charges, which carried up to 14 years in prison for each case. Those felony charges are now gone. She faces a maximum of 5 years on each count in the new felony case. And in the misdemeanor case, I think she's looking at a year and 6 months total, basically for trying to, for lying to the police and trying to get her friend to lie to the police. So no one's actually charged with the death of the children. They are charged with delaying or hindering the children or the discovery of the children's remains and things like that. So we shall see. So let me see if there's a couple of other questions here. It got somewhat stalled, the thing, because I think I paused it. And yes, thanks to all the mods. Absolutely. And, just like me, when I say something, the mods, the moderators, some people say, well, why can't you say this? Why can't you say that? Hey, as long as you can keep it respectful and clean, we don't have to agree. No one's looking here for, somebody to sit and say, oh my gosh, Scott is absolutely right all the time. And if you don't, mimic what I say, I like a good debate. I can assure you of that. So the mods, be nice, be respectful for them. I mean, it takes a lot to get blocked, but if they're blocking you, you probably said something you maybe should have rethought. Doesn't mean it was wrong, but maybe it means that it could have been done in a little more friendly, articulate way, for sure. Ginger, yes, the Brown and Taylor case. I've read a lot of the documents released. I can't say I've seen all of them. I don't know if there were some new ones today, which is another thing. Somebody asked me today, said, how come you don't answer every question or nearly every question in the comment section? I can tell you, every video, not every video, but just about all videos, we get between 600 and 1,500, sometimes thousands of responses. I apologize. I simply do not have enough hours in the day to go and respond to everybody. If there's an overwhelming question, we try to address it in our next video. But I get notifications. Don't get me wrong. It bugs people why I think they're always looking at my phone and seeing that, the people, the comments that come up. And I try to respond to many of them. And sorry if I don't respond to yours, but I'm doing my best. I promise. Yeah, and I don't, the Brown Taylor, I'm not familiar if there's new information about drug involvement. I can't, see how that is. And if you want to volunteer as a mod, I think you just need to contact Frank and he can get you set up. I think that's how we're doing that now. Okay, a couple of questions on the Scott Peterson matter. Well, before we get started there. Scott Peterson, obviously he was on death row for killing his wife, Lacey, an unborn child. Gosh, what are we, like 16 years later now? And the California Supreme Court said, hey, the jury wasn't allowed to have people on the jury that, although they seem to be, what's the word I'm looking for? They were death qualified, because in any kind of death penalty case, if you go in and you say, I will never consider the death penalty as morally wrong, guess what? You're not qualified to be a juror, because a juror has to be able to follow the law. And if you can't follow the law and you basically say, I'm not going to follow the law, you're not qualified. Well, apparently there were jurors that said in this Peterson case, early in the voir dire process and the death qualification of the jurors, that, well, they don't like the death penalty. I guess I could follow it if that's the law. Well, the judge said, you know what? We're not playing this wishy-washy game. You either can say you're going to, pull the proverbial trigger on the death penalty case. And if not, if you're going to get wishy-washy, we don't need you. The California Supreme Court reversed on those grounds. There was also some issues as it related to effective assistance to counsel regarding potential witnesses who maybe would have been able to say, and that weren't called to the witness stand, regarding the timeline as it relates to when they saw Lacey Peterson last at the house. And some people say, I think it was even the mailman that said that it could have been while basically the police had put in the timeline that she was already deceased, which would throw a big hiccup in that. Now, whether the defense, didn't call him, chose not to, those are tactical decisions. But at the end of the day, most people that have, death penalty charges, most of the attorneys, I mean, who knows, I know that Scott Peterson has always maintained his innocence, but a lot of the attorneys that do the appellate work, they oftentimes consider their job done if they make the death sentence go away. So, there's so many things going on in the, true crime genre, so to speak, with all of the cases that are going on. it's an interesting time, and with so much information where you come out where you can actually, see the briefs, see the orders, which were, for years ago, not that many years ago, was absolutely uh, difficult to get into and see. It's amazing how easy it is these days to see the actual documents, and it's, I don't know, it's just interesting. So, all right, so let's reset. My name is Scott Reisch. This is Crime Talk. For those who haven't joined us before, we talk true crime. We talk current cases. We talk facts. We talk the law. We don't get into a whole lot of speculation. We like to tell it how it is. We're kind of the true crime of Realville. We talk the facts. That's it. So let's see here. Let's take a look. So the manner of death for the kids was homicide. Why aren't Lori and Chad being charged with murder? Those children were brutally murdered. It would appear as though they were brutally murdered, at least the remains of Kylie. Obviously, the remains were burned. So at least her remains have been brutally treated as well. And we've talked about this, and there's lots of people that say, how can you have the bodies of two dead children on your property related to the woman that you're seeing while your wife is still alive, who mysteriously dies, then get married 2 weeks after the death of your wife, go off to Hawaii, be with Lori Vallow, and have no idea how those bodies got there? It's called proof. It's called evidence. And you may not like it, but that's the way the law looks at it. No one has been able to say who placed those bodies on that property. When were they placed? Were they placed, by Alex Cox, the now deceased brother of Lori Vallow? Did he do it alone? Did he have the assistance of someone? Those are all questions, and there's no answers to them, at least definitively. There's a lot of speculation, and we can speculate, sure, but speculation doesn't get you an affidavit for an arrest warrant and charges for murder. In fact, it gets you thrown out because a judge is going to look at it and say, speculation isn't going to do it. What witness, what evidence do you have is going to come in and say, those two people over there, Lori and Chad, either conspired with Alex Cox or did something, and they caused the death? Where? Was it in Wyoming? Was it in the great state of Idaho? Where was it? How'd they get there? Who put them there? Those are all questions that need to be answered before somebody can be charged. So I get it. I get the frustration. You think, why, it's so obvious. Obviously, they did it. But if you've ever had to present a case, whether as a prosecutor or as even on a plaintiff's attorney side, you have a ton of work to do. You have to know, can I get that evidence in? Who's going to be able to present the evidence? Who's going to be able to testify as to what they saw? If there's documents that need to be presented, how do I authenticate those records and say, okay, these records came from Alex Cox's phone, but how do I know Alex Cox was the one on the other end of the phone? Maybe he left his phone here and somebody picked it up and knew the password and started typing in things into the phone. Those are issues that prosecutors have to deal with. Those are things with defense attorneys think about. How can they do this? How can they prove this? Okay. I had a very, very serious trial. It was the end of last year. And, very nice young prosecutor. She was very, she started off very nice. And then when I said, no, we're going to trial, she became very hostile and was like very mean. But I was like, okay, that's all right. Well, guess what? They called their first witness to the stand, and they thought that they were going to introduce various phone records in so that they could show this grand conspiracy. Well, not to say I'm the greatest trial attorney, but I was able to tell from their witness list that they had never endorsed the person from a phone company to come in and authenticate the records as it relates to business records. They thought that they were just going to have the police officer say, oh, well, here's the phone records that we got from a subpoena from our records. It doesn't work that way. You have to bring somebody in to say how they save those records and what everything means in there, and that they're kept in the ordinary course of business and maintained, etc. They didn't have that. So their first witness destroyed their case. They didn't have them under subpoena, and the judge fortunately knew the rules of evidence. And so none of that evidence came in. And let's just say that that young prosecutor, who, although started off very nice, became less hospitable when I said, we'll just go to trial. And let's just say she was very nice when she had to say, fine, I'll give you exactly what you want, because she knew she wasn't going to be able to prove her case. So it's there's a lot of things out there that you have to be able to show that evidence. It's not just saying, here's a document. All right, who's going to testify to it? So there's no proof of that. And frankly, unless one of these two, Chad and Lori, if they roll on each other and agree to testify against each other, that is the only way that I see charges coming down as it relates to the murder of JJ and Ty Lee. Who else is going to testify to it? Unless there is some sort of an admission, which so far they've been able to keep their mouths shut, and it could possibly be they just don't know, or they've been able to realize that if they ever reveal a secret like that, they will probably go to prison for the rest of their lives. So that's why there's been no charges. They just don't have the evidence. I don't think that they'll get it. And although I think it's very odd that you have, two children that were missing, that you did, the mother and the now, new husband took no steps to, really try to assist the police in finding these children. Why is that? Well, probably because they knew there was, they weren't going to waste their time. They knew the children were dead, right? And I hate to say that's the case, but I don't think it's necessarily a slam dunk for the prosecutor, Mr. Wood, on either of these cases, because the questions of how they get there, what evidence do you have that they knew that the bodies were there? They're saying that, they're hanging their hat on a text message saying, oh, it was strange today. I was out by the pet cemetery and I shot a raccoon. Okay. In the words of Freud, sometimes a cigar is just a cigar, right? Maybe there's nothing you can read into it. Maybe he was really out there and shot a raccoon. Just saying. So I don't think they have necessarily a slam dunk case for the prosecutor. Sure, it looks weird. Sure, someone has some explaining to do. Remember, the defendant never has to explain anything. The prosecutor is the one that has to do it. And I think, although they got past a preliminary hearing, it may not be sufficient to the standard of proof beyond a reasonable doubt at trial. So we will have to see. All right, here. Purple Sneakers, super chat. Could Leticia, referring to Leticia Stauch, her letters help her defense in the incompetence, insanity type plea deal? Well, for those of you who are not familiar, obviously, Leticia Stauch is the mother charged with the death of Gannon Stauch. She's a stepmother, to be accurate. And she has been arrested, extradited back, attempted to escape, was charged with an attempt to escape case while she was in the El Paso County Jail down in Colorado Springs. And she's currently under a competency evaluation based upon the request of her attorneys. So some of the ramblings that the judge witnessed in the letters that were sent to him probably some of the typical ramblings that the attorneys experienced, which caused them to want to know whether she is, really there, and if she appreciates and understand what's taking place. And so I can assure you, we mentioned this in our video the other day, this is the worst thing nobody likes getting a notice from the court that your client is writing letters to the court. I've literally had clients that have confessed when they wrote a letter to the court because they just wanted to go home. They just wanted to, judge, you keep denying my bond. And by God, if I just wrote that letter to the judge, he would get it. He would just understand. And sure, I did some bad things, but he's going to let me go. No, he's not. No. But somehow, and I don't get it, to the end of my days, and I'm not taking away anything from anyone who's represented themselves pro se, but there's a little mug and I think somebody got me this mug at some point, and it said, "Don't replace my law degree with your Google search." Now, a lot of people can get educated on an area of law and can become familiar with it. I get it. Okay. And people think, I've watched a YouTube video. I watched that Scott Reich guy. He's explained stuff to me really well. I don't need any lawyer. I'm not paying those exorbitant fees. Okay. We refer to this as the do it yourself and save mode. All right. When I was a young man in high school, I worked at a full service gas station. The kind where you actually went out, you pumped gas, you checked tires, you sold, you checked the oil and you sold them oil and you sold, hey, those tires looking bad. And, you got commission, and all those types of things. And every now and then there was always a thing where the tow truck would have to go and pick up some car from some guy's house because he was going to do it himself and save. He wasn't going to pay some mechanic that knew what he was doing, had seen this issue 100 times and tackle it. No, he was going to be a shade tree mechanic, take care of it himself. He usually wound up costing twice as much as if he had brought this car to the mechanic early on. Same thing when it comes to the practice of law. Okay. Now, do I personally think that everybody, that you would have to go to law school to be a lawyer? No, it's 3 years. You go, you learn what you need to learn, and just enough to be dangerous when you get out of law school. And I mean that. First year of law school, you're super dangerous because you think you've taken all these classes and you know just enough to be dangerous. Even by the end of law school, you know just enough to be dangerous, but enough to pass the bar exam. All right. And let's face it, you need adult supervision as a young attorney. And at the end of the day, you hope you get, and how do you get that? Hopefully an experienced attorney looking over you. Hopefully someone making sure you don't embarrass yourself and those around you. But today, people want to do everything themselves. I watched a video on it, and I'm telling you, I tell everyone that calls me, I say, listen, I understand. Maybe you can't afford my services. Maybe you can't afford any private counsel's assistance. But I tell them, then go get a public defender. This is a criminal case. Your liberty is at stake. We're not talking about a car being repaired. All right. Always get yourself an attorney. How do you know if you're getting a good deal? And I assure you, ladies and gentlemen, if you go in and say, I'm going to handle this myself, how do you know if that district attorney is giving you a good deal? Maybe they can't prove their case, but you haven't checked out the discovery. And even if you got it, you wouldn't know exactly what they were looking for. The district attorney is not your friend. Your district attorney is not there to tell you the good and bad of the case. It's simply to relay an offer. And so I tell everyone, get yourself an attorney, whether it's me or somebody else. Always go to court with an attorney. You shouldn't do it yourself. I truly believe that that is the case. And, just, you can't, just don't do it. And like I said, I believe that, that's how most people get into it. And a lot of people, like I said, like Leticia Stauch, writing letters to the judge is one of the worst things anyone could possibly do. One, it shows the ramblings of possibly a delusional individual who maybe is not in touch with reality. When you read her letters regarding the flag and she's a good American and got to get back to work and going to work on her PhD, all may be completely rational. It's like, well, if she's working on her PhD, she can't be in some sort of psychosis or delusional. Oh, yes, she can. She absolutely can. So you need to, you need to really, really think twice about that and listen to your attorneys, people. I mean, please. I tell my clients, and I would tell, just like I would tell my subscribers, anyone that's watching these videos, I would not give you bad legal advice, at least not knowingly, at least not saying, I think today I'm going to give the client the wrong legal advice so that they make the wrong decision. No, attorneys don't do that. All right. It's kind of like my kids. And I think I've explained this before, is that, and every teenager should listen to this. Okay. Your parents, they love you. All right. And attorneys treat their clients like their own children in the sense that they want you to do well, to flourish. Why would they? Just think about it. Did your parents ever intentionally give you bad advice? I sure hope not, but I would never intentionally give bad advice to my children. Same thing why I would never give bad advice to my clients. I give them the best advice I can based upon the information that I have. And it's so true. But yet some people, and I have a case very recently, worked out a spectacular deal. It's great. Everything that the client had concerns about were dealt with in it. We could appeal it. It was fabulous. He's not taking any deal. Okay, let's go to trial. All right. I'm not going to sit here and beat you up to do the right thing. You're a big boy. You've got it told to you to your face. You've got letters sent to you. I told you you're proceeding against my advice. Well, let's go do it. I'll go do my lawyer stuff and we'll see. Who knows? Maybe, we'll go from there. So, just the way it is. So Leticia Stauch writing letters, bad. Every attorney's worst nightmare. Every attorney's worst nightmare. That's for sure. Let's see here. We can kind of jump to the Kyle Rittenhouse case. And for those of you who aren't familiar with the Kyle Rittenhouse case, this was the young man. He lives in Illinois, but went up to Kenosha, Wisconsin. His attorney really gave a defense of him the other night on television, which hadn't been produced. First of all, he said that the firearm did not go over state lines from Illinois to Kenosha there in Wisconsin, and that he was doing nothing wrong by possessing the firearm, even though he was under the age of 18. It was open carry, etc. And the attorney in that particular case says that it is absolute 100% self-defense. Now, we have some video. We've shown it the other day, tried to break down the timeline. And there's really two events in that entire process. One is where a gentleman was standing near, it was actually near a reporter who got shot in the head and ultimately died. And then the second one was when Rittenhouse was running away again, where he tripped and fell, and then individuals jumped on him, tried to, looks like, take his firearm, perhaps to disarm him, perhaps to do some serious harm. And one of the individuals was there, struck Rittenhouse with a skateboard. The other one had a firearm and ultimately got shot. But the attorney for Mr. Rittenhouse, who is 17 years old, like I said, states that it is absolute 100% self-defense. He states that apparently Rittenhouse is a good kid, and I'm taking his word at what he's saying here. I have not independently verified it, so take that for what it's worth. He says apparently this Kyle Rittenhouse kid was a good kid. He works as a lifeguard, apparently wants to be a police officer or something to that effect. I'm not sure that's going to work out for him. But then they have friends up at the Kenosha area, and apparently Rittenhouse thought that he would go up there. They apparently removed graffiti from the school that had been vandalized earlier in the week. They were gone up there. Some sort of friend, I don't know if it's a family friend, but somebody had businesses that had been burned down and asked a couple of people to basically guard the property to protect what was left. Rittenhouse apparently also took a first aid kit in case any of the rioters, in fact, got injured. He wanted to be able to provide first aid because apparently that's kind of who he is, according to his attorney. Now, the first shooting, where it is alleged that Rittenhouse somehow turns around and basically shoots the firearm, and if you take a look at the criminal complaint, it's the first degree reckless homicide. Basically, recklessness. That's reckless homicide, where the sense, that's the classic definition is it's not after deliberation. It's not like, oh, I'm going to shoot this person, do it. But it's so reckless that you would think that someone would get shot, i.e. shooting a firearm down a crowded street, right? That's kind of the classic definition of a reckless homicide type situation. Now, the attorney then goes on and says, hey, no, that's not the way things happened. Apparently, according to the attorney for Mr. Rittenhouse, he states that his client was putting out a fire, and apparently the lines between the rioters and the police kind of shifted, and he somehow got stuck in the middle, and that ultimately these people, the rioters, became upset because he was trying to put out a fire that had been started. And he apparently, according to his attorney, was fleeing the scene, and that shots were somehow fired, and the Mr. Rittenhouse at one point returns fire. Now, is that reckless to just return fire, shoot in the general direction? I don't know. Obviously, the person that, for there to be self-defense, you usually can only use that self-defense on the person that was doing it. You can't say, well, I shot my gun because I heard a noise over here that I believe to be a gunshot, but I hit this guy who was unarmed. I think there's a little bit of a problem there. Now, I'm just trying to analyze it legally here. Then apparently Mr. Rittenhouse then runs down the street. As he continues to run down the street, he trips, he falls. He's, I think, basically jump kicked by one individual. There's another individual that hits him with a skateboard, and then another individual that had a gun that was going to go at him and is ultimately shot, but does not die. So in those situations, self-defense looks much more plausible from what I have seen and heard. Now, obviously, the attorney for Mr. Rittenhouse is being an advocate for his client. And okay, I get it. There's a gun that goes off, he turns, he shoots. But self-defense, I think is a little tougher on that first shooting than the second one. Because, like I said, you can only use self-defense as it relates to normally the individual that is deceased. You have to use reasonable force as against that person. If that person is just a standard bystander on a street corner, he's going to have much. He may not even get a self-defense instruction as it relates to that particular charge. So I know some people are going to say, well, that's a great analysis, Scott. Others are going to say, Scott, you suck. These people were attacking him. I get it. I'm telling you what the legal standard is and how those facts apply to the legal standard. These are the things that criminal defense attorneys do all the time. You may like your client a whole bunch. You may think, man, if it was up to me, I'd send you home right now. But it's not. It's up to the legal system, and it's up to the jury instructions and the law as it relates to those to the facts. So it's going to be very, very interesting to see how things go in this case. I think there's a lot of legal issues. The law of self-defense varies from jurisdiction to jurisdiction, and I think that it's not as clear cut on either side as any side would be. Some people think, oh my gosh, he killed somebody. He had a gun. He's under 18. He is guilty, guilty, guilty. Okay, he may be guilty of some of them, but not all of it. Other people saying he's absolutely innocent. He's up there defending against rioters. I understand, but you can only shoot people that are threatening you. So it'll be interesting. You know, self-defense law is a huge, tricky area of law, and it changes all the time. Right. Emmett Julian, big super chat here. So we'll take his question here, even though it's not related to necessarily Rittenhouse case, but it says, is it possible for someone who's not a party to a case to provide evidence that someone involved in the case has lied on the affidavit? How would you present this to the court if possible? Well, if you have evidence that the person that drafted the affidavit was not truthful, you could certainly turn that over to the defense, or you could turn that over to the district attorney. Hopefully they would do the right thing and look into it and see if it was valid or not, and take it from there. It just it depends. It's not like you can file and intervene and say, oh, look, I have the evidence. You have to be able to prove it, just like what we've talked about earlier is what proof do you have that somebody lied on an affidavit? So, Emmett, hope that helps your hopefully that answers your question. Can't he legally carry a rifle as a minor? Rebecca, the answer is possibly. You know, obviously people younger than 18 can possess firearms. People go hunting all the time. You think, you know, some kid out on a farm that's dealing with, you know, wolves or something coming to his property can't pick up a firearm. You're going to charge him with possession of firearm? No. Let's take a look at the firearm charge as it relates to Mr. Rittenhouse. Where was that? Let's go right here and let's see. That was, I think, the last charge in the indictment. I guess it was complaint, but let's see here. Possession of a dangerous weapon by a person under the age of 18. So it reads that the above named defendant on or about Tuesday, August 25th, in the city of Kenosha County, Wisconsin, being a person under 18 years of age, did go armed with a dangerous weapon, contrary to the section under the Wisconsin statute, a class 1 misdemeanor, and upon conviction may be fined not more than $10,000 or imprisoned more than 9 months. Oh, apparently, according to the statute here in Wisconsin, there apparently is a subsection under section 948.60, subparagraph 2A, and section 935.51, paren 3A, that apparently a minor cannot have a dangerous weapon. I'm sure there's going to be attacks made to that, but at the end of the day, it's a misdemeanor. That's not that big a deal, particularly when you're looking at life in prison. So it's, I don't know. I think that'd be the least of my concerns if I was the young Mr. Rittenhouse, particularly when he's, you know, fired for that. Now, Lisa says, I just find it weird for a 17-year-old to go get involved with a gun, kind of feeling in between here. You must be 18 to buy a hunting rifle or shotgun, only for hunting. No handguns are high powered. Yeah, certainly at 18, but you can have it in possession of your parents and things like that. Normally in most states, you can give them as a gift to someone under the age of 18. But the reality of it is, I mean, I don't know about you, but I had a pretty responsible child. But at 17, if there were riots going on, I certainly would not have sent my child down to protect somebody's building. Maybe if I was there, but even then, I think, why would I want to put my child in this situation to go be there? I mean, listen, if the parents had said, if he said, hey, I'm going up to Kenosha to go protect some property, maybe, clean up a little vandalism, me as a parent would be like hell you are. You're going to be home by 7 p.m. You're not going anywhere near Kenosha. Nothing good is going to happen up there whatsoever. I don't know what to tell you. I just think, no matter how devoted some people are, I mean, to protect, I get it, but it's stuff, it's property. I get it. If I had a building or a home that was burned down, I'd be mad as hell and I would be out there protecting it. I assure you. But I'm not sure I'm going to go out and protect somebody else's property, even if they do kind of know me. And I'm certainly not going to take my 17-year-old kid just because I wouldn't want to put him in any kind of situation that is going to affect his future, affect his livelihood, put him in a situation where poor decisions can be made. So that's just my opinion. And it has nothing to do whether he's guilty or not. Like I said, I think the second incident where he shoots and kills, allegedly kills someone, and then shoots the other individual in the arm who had a gun against him, those charges of self-defense are a little bit more easier, but it is no guarantees that he'll be found not guilty. The first one, I think he will have a little more problem. I really do. I don't think that's as clear cut as can be as it relates to self-defense, and, frankly, as a criminal defense attorney, I wish good Mr. Rittenhouse and Rittenhouse and his attorneys well. They have a lot of work head out for him. You always hate to see young men of any, situation, socioeconomic, racial background, be looking at spending the rest of their life in prison. I mean, it sucks, and particularly when there was something that was so preventable by simply just not being there. If somebody said, hey, there's going to be a riot tonight, I think I'll leave that to the police. Now, it's one thing if they're coming up on your property, you're going to defend yourself, but to go do somebody else, protect somebody else and put yourself, I wonder if that property owner's footing the bill for the attorney's fees at this point. So I doubt it. Patty that makes sense. Now I feel stupid, but thanks all the same. Could you say people was just trying to apprehend a guy that just murdered another one? Well, that's what the prosecutor is going to say. Walter can say that they were just trying to apprehend him, and he had a gun, so they had to, do something to make sure that they didn't get shot. That is exactly what the prosecutor is going to say. No doubt. I'm sure there'll be testimony from the guy with the Glock, and I don't remember his name. I could look it up, but I don't want to because I don't want to spend the time looking that up when we have other things we can talk about. But that's exactly what the prosecutor is going to do and argue, is saying, hey, these guys weren't trying to kill him. They were simply trying to apprehend him because they knew that he had shot this other guy. So Yeah, that's what the prosecutor is going to argue. That's why there's no such thing as a slam dunk case, ladies and gentlemen. No such thing as a slam dunk case. So, like I said, it's always tough when you have young clients, but as I have to tell lots of my clients when they get frustrated as to why the case isn't better, why is the case not being dismissed? Why am I not filing that motion to dismiss for lack of evidence? And I have to tell them, I am not the one that has created the facts that have brought us here together. I am simply dealing with those facts. So that's where it is. Paula, I understand that he was asked by the store owner to protect those guys. I get it. And then my question is, I wonder if that store owner would love to pay his attorney's fees. Does he feel any sense of responsibility whatsoever? And I'm not saying what he did. Hey, if maybe he thought he was being the most responsible guy out there. He seems like a mature 17-year-old. But 17-year-olds are still 17-year-olds. There's a reason why, their minds are still developing, because they don't make good decisions. Let's see. Not even characters in slasher movies get shot so many times. Love this channel. Thank you, Perla. Yeah, I mean, I'm assuming you're talking about the Jacob Blake matter there, but which is the other case we were going to talk about. And a lot of people got upset with me, accused me of being horrible things, because they said, listen, I think that the officer in the Jacob Blake matter is not going to be charged. And I'm not saying that I don't think he doesn't necessarily need to be charged. I mean, you shot somebody in the back, holding him by his shirt as he's walking away. Hardly, somebody that's attacking you and at most resisting arrest, which is misdemeanor in most jurisdictions. But apparently Mr. Blake has told the police that, yes, in fact, he did have a knife, that it was found in the car. And the police officer, more than likely, if has not said it already, is that I saw the knife. He was trying to get away from me. I believed he was going to get the knife to harm me. I don't think most prosecutors are going to take that case. And if they thought that there was, I'm not saying it's justified in the sense of he was right, but I don't think that the prosecutor is going to charge him in that particular case. We will have to wait and see. These cases are not always as clear-cut as we think they are, and that's unfortunate, but we will have to wait and see. Says his lawyer said no one has talked to him about a knife. Relaxing white noise, natural sounds, ambient music. Okay, I believe I had read a story where he had given an interview, and he said that he had admitted that he had a knife. So we'll just have to wait and see who is the accurate one on that. I'm not saying relaxing white noise is inaccurate. I don't know. I had seen it a couple of places that he had admitted that there was a knife. There's a picture where it appears as though he had a knife, at least in his waistband at one point, but the picture is not perfectly clear. So we'll just have to wait and see. I mean, don't get me wrong. 7 times in the back. Really? Normally when you shoot somebody in the back, self-defense doesn't go a long way. That's for sure. So we'll see. So we have been talking just about an hour now. And Frank, the hardest working man in show business, was telling me that the Patreon site is down. Frank, does that mean that we cannot go live?
No, we'll try. We can try to go live. I mean, there's a lot of places that Patreon is.
Okay.
The entire site.
Okay, so apparently the entire Patreon site is down. So I think it would probably affect our emails. Is that it? So we'll see if that works. Hopefully it works, because I like hanging out with our Patreon members. and talking really one-on-one. It's I kind of like the phone calls too. It's kind of, you know, I like the chat, but it's you know, it's kind of nice to have an actual conversation as well. So, you know, we'll just have to wait and see. I mean, ladies and gentlemen, this is there's so much stuff going on in the news right now about cases that are ongoing, and it's just exciting to talk about. It's exciting to talk about with people who are interested in the law. That's what I mean, this is what I do for a living. And yes, there are days where I think, man, I just want to go work at Starbucks or something, and not have to deal with all the issues that come up, because you're constantly putting out fires. And, you know, there's only so many hours in a day, and you do your best. And, but it is truly interesting. And even after 25 years, I literally learn something new every day. That's what I love about the law, is that, you know, you can have new cases and new scenarios that come up, and literally you learn something new every day. And what I love about this job, it's never the same day twice. And what I hate about it is that it's never the same day twice. You can have your day completely planned out, and literally one phone call can change the day. Somebody got arrested, somebody got you know, being questioned, you know, everything, and your whole day where you had it all planned out, scheduled, goes to completely gone. And so it's they think, okay, those 8 hours of work that I didn't get to do today, where am I going to find those 8 hours to make all that up? It is that's the biggest problem. There's simply not enough hours in the day. And even when you have other attorneys that work for you, even then there's sometimes not enough hours in a day. So we're going to let you all go right now. We're going to see if we can go to our Patreon page. Apparently there may be some issues regarding the entire site being down, but we are going to try and do it. So if you have not joined, well, you may not be able to if the site's down, but please do join our Patreon page, and we will see if we can get that up. And if we can't get it up, we'll do it again real soon, hopefully sooner than next Tuesday as well. Thanks for watching Crime Talk. We appreciate everybody tuning in. Thank you very much. And as always, this is made possible by our sponsors. So please go to crimetalksearch.com. You can go to crimetalkoffers.com and see other items that we have available from sponsors. And as well as you can go to crimetalkalarm.com, which is a great value, because I received a quote on a home security system, 8-channel DVR, like high-speed, low-drag stuff, $3,000. But if you go to crimetalkalarm.com, you can get literally a system that does it all. The backup, the video, the technology is amazing. For far less, 25% of what the quote that I received for in a system. So that's why we're sticking with the Sonicare system. Go to crimetalkalarm.com. Thank you very much. Have a wonderful night.